Hey folks, welcome back to the channel. Today's case brings us a defendant accused of assaulting the mother of his child twice in one day. When police found him hiding in a closet, things only got worse. With visible injuries on the victim and a history of probation violations, the judge isn't going easy on him. Let's see how this courtroom drama unfolds.
State of Michigan versus Jody Doris, counsel.
Thank you, Magistrate Steve Benson, for the people.
Jessica Shiva on behalf of Mr. Doris, who has formal reading and respects constitutional rights and stands mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I'll hear arguments as to bond, please.
We're asking for a $10,000 cash as surety. We're asking for a tether and a curfew. Curfew because, Judge, as you can see, the incident, at least the second incident of the two, occurred at 4:30 in the morning. Here, the way I read it, we had a 2-for-1 in the same set of allegations. First, the defendant assaulted the mother of his child in an earlier instance, punching her in the mouth, busting up her phone. Apparently, he didn't like what he saw in that phone. And then the police were called and a police report was made. And then later on, it appears in that same day, the police were called again. This time, the complainant was allegedly beaten again by the defendant. And the complainant in that particular instance had visible injuries, including a busted lip, bruise on her arm, and scratches on her neck. And then the police end up finding the defendant hiding in the closet. In addition to these allegations, Judge, the defendant is currently on probation. He ended up pleading September 8th of last year to controlled substance delivery and manufacture less than 50. He was sentenced to probation October 24th of 23. He got 3 years probation. In less than a year, he's had 2 probation violations. And pursuant to Odyssey, Judge, there was a warrant that was out for his arrest in May of 2024, where he was under remand status. Apparently, there was some type of an arraignment on that, though, because subsequent to the remand, it appears as though he had a $25,000 personal recognizance bond that was issued. But nonetheless, he's had 2 probation violations on probation at the time of this offense, and it's highly assaultive. So respectfully, we're asking for that cash with tether and a curfew.
Your Honor, charge is a misdemeanor. My client's 23 years old. He has nothing on his record other than the drug charge, that the controlled substance charge that was just mentioned. He has nothing assaultive on his record that he's ever been convicted of or pending. He has his GED. He's a lifelong resident. He lives with his mother, not with the complaining witness. There is no issue whatsoever with the no contact. He indicates he never wants to see her again. And there will be a court order, and he understands that. Your Honor, I'm not aware of capious history. Now, we understand that the people mentioned, probation violation hearings, but sometimes probation, we didn't represent him on those cases, and those violations could be anything from, missing if he has to test or not, doing what he's supposed to. We don't know. We don't represent him on those. If the court wants us to do a breakout room, we can. But what's in front of us right now is a misdemeanor. Respectfully asking the court to consider a personal bond. And if the court is not inclined to do that without a tether, then we understand. But we know the tether is going to have him go to the county and wait for it because they are backed up. And these are allegations. And the police, the first time don't find enough to arrest him. They leave without arrest, whatever was going on between the parties. And I know that they're called again, but still, he's still presumed innocent unless proven guilty beyond a reasonable doubt. His story is different than what's in the report, so he will have his day in court, Your Honor.
Hey, Judge, in addition to that,
I'll ask you if I need any more help. Just give me just a minute. This is charged as a misdemeanor, so I'm inclined to a personal bond. However, I think there are both indications of risk to community safety to this complainant and of flight in this case. Complainant had physical injuries which were observed by the police. The phone is broken. That's another observation. So we do have just allegations, but we have evidence in this case that this did actually occur. Because I do not want this to continue to escalate and result in injury to the complainant, I am inclined to a GPS tether with full home confinement since he's living with his mom. Is also not to have any contact or attempted contact with the complainant, no verbal contact, no written contact, no contact through third parties or social media. Any attempted contact would be considered a violation of conditions of the bond. You may not purchase or possess any firearms or other dangerous weapons during the course of your bond. And let's see about this address. Defense counsel, this is defendant's cousin's house where this occurred.
Correct.
All right, so I'm not going to do a no-go to that address unless the complainant resides there. I don't have any information to suggest that she does, but I don't want any contact with her. So if she's over there because it's a place she hangs out, well, you'll be on house arrest. You're going to be on house arrest till the judge says otherwise. All right, $20,000 personal, full home confinement until a judge says otherwise. Mr. Vincent, is there something else you'd like me to know? Also noting for the record the hiding in the closet causing me concern about flight risk. Mr. Vincent.
In addition to the fact that he's on probation at the time of this offense, he also did plead in July of 2020 to an RCSP motor vehicles as well as an R&O. And that ended up getting deferred under HIDA. He got 2 years there, then ended up picking up the controlled substance. So just wanted the record to reflect that.
All right, thank you. This is a misdemeanor that's not likely to result in incarceration even upon conviction. I don't know, given the record and the other stuff that's going on, but it's charged as a misdemeanor DV. So
Okay.
We'll do the GPS with full home confinement at this time. Next court date's going to be a pretrial, September 25th, 2024, in front of Judge Bryant. Thank you.
He really thought hiding in a closet could keep him out of trouble, but the courtroom had other plans. With his past catching up to him and the judge focused on the visible injuries to the victim, this case shows just how serious these charges are. What do you think? Did the judge make the right call? Let me know in the comments. And don't forget to like, subscribe, and hit that notification bell for more courtroom moments. See you in the next one.